Alright, before we get into the heart of this, it is absolutely critical to understand that I am not an attorney, and the information in this video is for educational and informational purposes only. This presentation does not constitute legal advice, and it does not create an attorney-client relationship. Every situation is unique, and the laws in your state can vary dramatically. Always, and I mean always, consult with a qualified legal professional for advice regarding your individual circumstances. Our goal here is to make you a more informed, more prepared, and more confident employee, not to replace professional legal counsel. Okay, let's get into it. You got the call. The dream job. The one you've been working towards for years. The interview process was a marathon, but you crushed it. The team is amazing, the work is exciting, and the offer is fantastic. You're celebrating, telling your friends, your family, you're ready to pop the champagne. And then it arrives in your inbox. A single PDF file. The employment contract. Suddenly the excitement freezes. You open it up and it's 10, maybe 20 pages of dense, impenetrable legalese. Words like indemnification, covenant, severability, and at-will jump out at you. Your heart sinks a little. You think to yourself, well, I guess this is just standard stuff. I'll just sign it. I don't want to rock the boat and lose the offer. And right there, in that single thought, is the most expensive mistake millions of Americans make every single year. The mistake isn't misinterpreting a single clause. It's the fundamental belief that an employment contract is a formality, that it's a take-it-or-leave-it document written in stone. It is not. An employment contract is not a set of rules you are being handed. It is the opening offer in the single most important negotiation of your professional life. And the vast majority of people walk into that negotiation completely unarmed. This series is going to change that. Over the next 10 parts, we are going to arm you. We are going to demystify every single line of a typical U.S. employment contract. We're not just going to define the terms, we're going to decode the strategy behind them. You will learn what's standard, what's negotiable, and what is an absolute red flag. You'll discover the hidden clauses that can limit your future career, the phrases that can cost you your inventions or side projects, and the specific language you can use to negotiate a better salary, a bigger bonus, a stronger severance package, and more protection for yourself. By the end of this, you will look at a contract not with fear, but with confidence, seeing it as a puzzle you know how to solve, a game you know how to win. But before we can even talk about a single clause, we have to start with the most misunderstood, most foundational concept in all of American employment law. It's a phrase you've probably heard, and it's almost certainly in your contract: at-will employment. What does it actually mean? Most people think it just means your employer can fire you for any reason. And that's partially true, but it's a dangerously incomplete picture. At-will employment is the default legal doctrine in 49 out of 50 states. Sorry, Montana, you're the special one. It means that, in the absence of a contract stating otherwise, an employer can terminate an employee at any time, for any reason, or for no reason at all, without any warning, and without any financial liability. Sounds brutal because it is. They could fire you because they don't like the color of your shirt, because you're a fan of a rival sports team, or literally for no reason whatsoever. They can just walk up to your desk and say, "You're done. Pack your things." Now, there are critical exceptions. They can't fire you for an illegal reason. This includes discrimination based on protected classes like race, religion, gender, age, or disability. They can't fire you in retaliation for being a whistleblower or for filing a workers' compensation claim. These are legal protections carved out by federal and state law. But outside of those specific, hard-to-prove illegal reasons, the at-will doctrine gives employers enormous power. But here's the part everyone misses. It's a two-way street. At-will employment also means that you, the employee, can quit at any time, for any reason, or for no reason at all without any notice. You can walk into your boss's office and say, "I'm leaving effective immediately," and walk out the door. The traditional 2 weeks notice is a professional courtesy, not a legal requirement under the at-will doctrine. So, why is this the most important concept to understand? Because the entire purpose of a written employment contract is often to change this default relationship. The contract is a tool to take you out of the wild west of at-will employment and into a structured agreement with defined rules. When a company hands you a contract, they are trying to do two things. First, they are specifying the terms of your employment. But second, and more importantly for them, they are often trying to cherry-pick the parts of the at-will doctrine they want to keep while getting rid of the parts that benefit you. For example, a contract might say your employment is at will, preserving their right to fire you at any time. But then, in the very next section, it might require you to give 30 or 60 days notice before you can quit. See what they did? They kept their flexibility but took away yours. Or a contract might define a specific role and set of duties, creating what could be interpreted as an implied contract, that you'll be employed as long as you perform those duties well, but then have a separate clause that screams in all caps. Notwithstanding anything else in this agreement, your employment remains at will. They are giving with one hand and taking away with the other. This is the game. Understanding at-will employment isn't just a piece of trivia. It is the entire foundation upon which your contract is built. It is the baseline. Every single clause you read, from termination to severance to your job duties, is a modification of that baseline. And if you don't understand the baseline, you have no hope of understanding the modifications. You won't know if a clause is helping you or hurting you. You won't know if it's giving you rights you didn't have before, or taking away the few courtesies the at-will doctrine afforded you. So let's reframe this. That PDF in your inbox isn't just a document. It's a proposal to formally change your legal standing from the default of at-will to a new set of rules. Rules that, right now, are written entirely in their favor. Your job, and what I'm going to teach you how to do, is to pick up a red pen and help rewrite those rules. To shift the balance of power, even if it's just a little bit, back in your direction. This isn't about being adversarial or difficult. It's about being professional. It's about treating your career with the same seriousness and diligence that the company is treating its business. They have a team of lawyers protecting their interests. You need to be the first and best advocate for yours. The power to negotiate better terms for yourself doesn't come from being a legal genius. It comes from understanding the game being played. It comes from knowing what to look for, what questions to ask, and recognizing that standard is just another word for what's best for the company. Now that we've shattered the myth of the standard contract and laid down the bedrock of at-will employment, we can start to dismantle this document piece by piece. We're going to start with the part that gets the most attention, but is still full of traps and opportunities most people miss. Let's talk about the number one reason you're signing this thing in the first place: the money. Your compensation. Your salary, your bonus, your equity, and all the fine print that determines whether you actually get to keep it. When you see that big, beautiful number on your offer letter, your annual salary, it feels concrete. Feels like a promise. But in most U.S. states, under at-will employment, it isn't. Think of your stated salary not as a guaranteed wage for the year, but as a rate of pay. A company can, in most situations, legally change that rate of pay going forward, as long as they notify you. They can't retroactively cut your pay for work you've already done, but they can come to you on a Friday and say, starting Monday, your new salary is 20% lower, and your choice is to accept it or quit. Now, is this common? No. A company that does this will see its talent walk out the door. But it happens, especially during economic downturns. The contract might state your starting salary, but you need to look for any language that gives the company the right to modify your compensation at their discretion. It's usually there. This is the first crack in the foundation of what you think you're earning. Next up, the bonus. This is where the language gets really slippery. You might be promised a target bonus of 20% of your base salary. The key word there is target. It's an ambition, a goal, a possibility. It is not a promise. Most bonus plans are labeled discretionary, which is the legal equivalent of a shrug emoji. It means the company decides if, when, and how much they pay based on a whole host of factors. Company performance, department performance, your individual performance, and sometimes just the mood of the board of directors. Imagine you crush it all year. You hit every single one of your personal goals, but the company as a whole misses its revenue target by a few percentage points. Your discretionary bonus could evaporate completely, or your manager, who decides your individual performance rating, might just not like you very much. Suddenly, that 20% you were banking on to pay for a new car becomes 5% or 0. And you have almost no recourse. What you need to look for are the magic words. Is any portion of the bonus guaranteed? A guaranteed sign-on bonus is solid. A guaranteed first-year bonus is fantastic. But a discretionary target bonus is just a maybe. You also need to check the payout conditions. Do you have to be employed on the specific date the bonus is paid out? Almost always the answer is yes. If you quit one day before the checks are cut, you get nothing. It doesn't matter that you worked the entire previous year to earn it. The fine print giveth and the fine print taketh away. Also, check for prorated language. If you start mid-year, will your bonus be calculated based on the full year, or just the portion you worked? Don't assume. Get it in writing. Now let's talk about the big one. The one that creates millionaires and also generates a tidal wave of disappointment. Equity. Stock options. RSUs. This is the part of your compensation that feels like you're winning the lottery. You're not just an employee. You're an owner. The company is giving you a piece of the pie. Except they're not. Not yet. Equity is the ultimate form of delayed gratification, governed by a set of rules designed to keep you chained to your desk. These are the golden handcuffs. The most important concept you need to understand is vesting. Vesting is the process of earning your shares over time. A company doesn't just hand you a big block of stock on your first day. That would be insane. You could just take the stock and walk out the door. Instead, they make you earn it. The most common vesting schedule in the United States is a 4-year vest with a 1-year cliff. Let's break that down because it's a sentence that has cost people millions of dollars. The 4-year vest means you will earn your full grant of stock options or RSUs over a 4-year period, typically on a monthly or quarterly basis after the first year. The 1-year cliff is the most brutal part. This means you get absolutely nothing, zero zilch nada, until you have been employed for 1 full year. 365 days. If you leave or are fired on day 364, all of that promised equity you were dreaming about vanishes into thin air. It's heartbreaking and it happens all the time. After you pass that 1-year cliff, you typically get 25% of your total grant. Then, for the next 3 years, the remaining 75% vests in small chunks every month. This is designed to make you constantly weigh the cost of leaving. Oh, I can't quit now, I'm vesting another chunk of shares next month. That's the handcuff clicking shut. But it gets more complicated. Let's say you have stock options, not RSUs. An RSU or restricted stock unit is simple. Once it vests, it's a share of stock. You own it. You'll pay taxes on its value, but it's yours. A stock option is different. It's the right to buy a share of stock at a predetermined price, called the strike price or exercise price. Let's say your strike price is $1. If the company's stock is trading at $50, that's amazing. You can use your option to buy a share for $1 and, in theory, it's worth $50. But what if the company struggles? What if the stock is only worth 50 cents? Your option is worthless. It's underwater. You would never pay $1 for something worth 50 cents. And here's the kicker. To turn those options into actual stock, you have to pay to exercise them. You have to write a check to the company for the total strike price. If you were granted 10,000 options at a strike price of $1, you need to come up with $10,000 just to buy the shares. This is money out of your own pocket for something that has no guaranteed value. It's paper money until you can actually sell it, which is often only possible if the company goes public or gets acquired. So you need to ask, what type of equity is it? What is the vesting schedule? Is there a cliff? If they are stock options, what is the strike price? And this is critical. How long do I have to exercise my options after I leave the company? This is called the post-termination exercise window. 4 years, the standard was 90 days. You quit your job and you had just 3 months to scrape together potentially tens of thousands of dollars to buy your vested options, or they would expire and be lost forever. Many companies are extending this window now, but you have to check. It's a detail buried deep in the stock plan documents, and it can be the difference between a life-changing payday and a handful of expensive, expired lottery tickets. Finally, while we're on the topic of money, let's talk about a terrifying clause you might find, the clawback provision. A clawback gives the company the right to take back compensation they've already paid you. Yes, you heard that right. They can reach back into your bank account and pull money out. These are most common with bonuses and commissions. For example, a contract might state that if you leave the company within a year of receiving a sign-on bonus, you have to pay it all back. Or if you're in sales and a client you sign cancels their contract within 6 months, the company can claw back the commission you were paid on that deal. This is a huge risk, especially in commission-based roles. You need to read that section with a magnifying glass, understanding exactly what circumstances could trigger the company demanding its money back. Because that salary, that bonus, that equity, it's not truly yours until you've cleared every single string attached. And as we're about to see, the strings don't stop with your paycheck. They extend to what you can do, where you can work, and even what you can say long after you've left the building. These are the invisible chains, the post-employment handcuffs that can dictate your career path for years. They're called restrictive covenants, and they are some of the most fiercely debated and potentially devastating clauses you will ever encounter. Let's start with the most notorious of them all, the non-compete agreement, or NCA. On the surface, it sounds reasonable. You agree that for a certain period of time after leaving the company, you won't go work for a direct competitor within a specific geographic area. The company argues this is necessary. They've invested in you, trained you, shared their secret client lists, their proprietary software, their strategic plans. They don't want you to take all that priceless knowledge, walk across the street to their biggest rival, and use it against them. It makes sense from their perspective. But let's flip the script. You're Sarah, a brilliant graphic designer at a mid-sized agency in Chicago. You've honed your skills for 5 years, building a killer portfolio. Suddenly, a dream opportunity lands in your inbox. A lead designer role at a top-tier, world-renowned agency, also in Chicago. It's a massive promotion, a 30% pay raise, a chance to work on global brands. You're ecstatic. You hand in your notice, ready for the next chapter. Then you get the letter. A cease and desist from your old company's lawyers. It reminds you of the non-compete you signed 5 years ago, a document you barely glanced at when you were a junior designer just thrilled to have a job. The agreement says you cannot work for any competitor within a 50-mile radius of downtown Chicago for 2 years after your departure. Your dream job is not just in that radius. It's 6 blocks away. Suddenly, your dream becomes a nightmare. You're faced with a choice. Turn down the job of a lifetime, or fight a legal battle against a company with infinitely deeper pockets than you. This isn't a rare hypothetical. It happens every single day. People are locked out of their own industries, forced to move states, or take lower-paying jobs in unrelated fields, all because of a few sentences they signed years prior. So, the million-dollar question is, are these things even legal? The answer is a frustrating, it depends. The legal landscape for non-competes is a chaotic patchwork that varies wildly from state to state. States like California, North Dakota, and Oklahoma have made them virtually unenforceable for employees. They believe that preventing someone from earning a living is a violation of public policy. But in many other states, they are very much alive and kicking, as long as they are deemed reasonable. And that word, reasonable, is where the entire fight happens. Courts typically look at 3 factors. First, the duration. A 6-month or 1-year restriction might be seen as reasonable. A 5-year ban? That's almost certainly going to be thrown out. Second, the geographic scope. For a local bakery, a non-compete covering the entire country is absurd. But for a national sales executive, a nationwide restriction might actually hold up in court. Third, and most importantly, the scope of the restriction. Does it just prevent you from doing the exact same job? Or does it bar you from working for a competitor in any capacity, even as a janitor? The more narrowly tailored the restriction is to protect a legitimate business interest, the more likely a court is to enforce it. And this entire battleground might be on the verge of a seismic shift. In early 2023, the Federal Trade Commission, the FTC, proposed a new rule that would ban non-compete clauses for employees across the entire country, calling them an unfair method of competition that suppresses wages and stifles innovation. While this rule is still being debated and faces legal challenges, it signals a massive tide turning against these career-locking agreements. But don't breathe a sigh of relief just yet. Even if the non-compete is dead, companies have other tools in their arsenal. Meet the non-compete's quieter, sneakier cousins, the non-solicitation and non-disclosure agreements. Let's say your contract doesn't have a non-compete. Great. You leave your job at a consulting firm to start your own. You're free to compete. But you want to bring your all-star project manager, Dave, with you. You call him up, offer him a great position. The next day, you get that familiar letter from your old firm's lawyers. This time, they point to the non-solicitation of employees clause. You agreed not to poach or even attempt to poach any of their employees for a year after leaving. You're sunk. Okay, so you can't hire Dave. But what about your clients? You spent years building relationships with them. They love you, not the firm. You decide to call up your top client to let them know about your new venture. Wrong again. The non-solicitation of customers clause prevents you from luring away any of the company's clients you worked with. Your entire book of business, the foundation of your new company, is now legally off-limits. You can compete, sure, but you have to do it with one hand tied behind your back, starting from absolute zero. And then there's the one that almost everyone has, the one that often lasts forever, the NDA or non-disclosure agreement. This is also called a confidentiality clause. This is the company's shield, protecting its trade secrets. What's a trade secret? It's a huge gray area. It can be anything from the formula for Coca-Cola to a list of potential sales leads. It's their customer data, their marketing strategies, their internal processes, the code for their software. You agree not to share this confidential information with anyone, ever. And unlike a non-compete, this obligation doesn't usually expire. It's for life. A casual comment at a conference about an old project's budget could, in theory, trigger a multi-million-dollar lawsuit for breach of contract. These three clauses, non-compete, non-solicit, non-disclosure, form a powerful trilogy that can control your actions long after you've turned in your keycard. But there's one more, and for creators, inventors, and innovators, it might be the most terrifying of all. It's called an inventions assignment agreement. Sounds innocuous. It usually says that any inventions, discoveries, or creations you make during your employment, related to the company's business, automatically belong to the company. During my employment, you think. So, stuff I do on the clock on a company computer. That's fair. But that's not always what it means. Imagine you're a software engineer at a large financial tech company. In your spare time, on your personal laptop, on your own Wi-Fi, you build a revolutionary new budgeting app. It's your passion project, your side hustle, your ticket to financial freedom. You launch it and it starts to take off. Then the letter arrives. Your employer claims they own your app. Why? Because your employment contract had an inventions assignment clause that was incredibly broad. It said anything you create that relates to the company's current or demonstrably anticipated business belongs to them, regardless of when or where you created it. And since they are a financial tech company, and you built a financial app, they argue it's theirs. You might think this is an exaggeration, but this exact scenario has led to brutal, company-crushing legal fights in Silicon Valley and beyond. Some states, like California and Illinois, have passed laws to protect employee inventions, but they have specific hoops you have to jump through. If you don't follow the rules precisely, that brilliant idea you had in the shower, that world-changing code you wrote at 2 a.m. in your basement, it might already belong to your boss. These restrictive covenants build a digital fence around your career. They don't just govern your past work. They attempt to colonize your future. They dictate who you can work with, what you can say, and even what you're allowed to create. It's a staggering amount of control to sign away. But what happens when the company wants even more control? What happens when they want to change the rules of the game after you've already signed on the dotted line? Can they just unilaterally alter your pay, your responsibilities, or your benefits by updating a handbook you never read? The answer lies in understanding the most fundamental and most misunderstood concept in all of American employment: at will. At-will employment is the default rule for nearly every private sector job in the United States, with the sole exception of Montana. It's a legal doctrine that sounds deceptively simple, but its implications are vast and often brutal. In its purest form, at-will employment means that an employer can terminate an employee for any reason, or for no reason at all, without warning, and without having to establish just cause. The reason can be good, bad, or utterly nonsensical, as long as it's not an illegal reason. Think about that. You could be the star performer, the employee of the month, the person who consistently exceeds every metric. But if your manager decides they don't like the color of your tie, or the fact that you cheer for a rival football team, or the sound of your laugh, they can fire you on the spot. And legally, in most cases, they'd be in the clear. Let's make this real. Imagine a graphic designer named Maria. For 5 years, she's been the creative engine of a small marketing firm. Her designs have won awards. Clients specifically ask to work with her. One Tuesday morning, she's called into her boss's office. He says, "Maria, today is your last day." She's stunned. She asks why. Her boss hesitates, then says, "We've decided to go in a different creative direction." Maria knows this isn't true. She is the creative direction. The real reason: the CEO's nephew just graduated with a design degree and needs a job. Firing a loyal, high-performing employee to make room for a family member feels deeply unfair. Feels wrong. But is it illegal? Under the at-will doctrine, no. It's not a pleasant reason, it's not a good business reason, but it's not an illegal one. This principle, however, is a two-way street. At-will also means that an employee can quit for any reason, or no reason at all, without giving any notice. You could get a better offer, win the lottery, or simply decide you're tired of the morning commute. You are legally free to stand up from your desk, say "I quit," and walk out the door forever, with no legal repercussions. While burning a bridge like that might be a terrible career move, it's your right under the at-will doctrine. It's a system built on the idea of maximum flexibility for both sides. but it's undeniable that the power balance heavily favors the employer. So, are you completely unprotected? Is your job security entirely at the whim of your manager's mood? Not quite. The at-will doctrine is not an impenetrable shield for employers. Over the years, courts and legislatures have carved out critical exceptions that provide a safety net for employees. Understanding these exceptions is the key to understanding your actual rights. There are three main ones. The first, and most widely recognized, is the public policy exception. This means an employer cannot fire you for a reason that violates a fundamental public policy. What does that mean in plain English? They can't fire you for refusing to break the law. For example, if you're a truck driver and your boss orders you to drive for 20 straight hours, violating federal safety regulations, and you refuse, they cannot fire you for that refusal. They can't fire you for performing a civic duty like serving on a jury. They can't fire you for exercising a legal right, like filing a legitimate workers' compensation claim after being injured on the job. And they certainly can't fire you in retaliation for reporting illegal activity, which is known as whistleblowing. This exception ensures that the fear of losing your job doesn't force you to become a criminal or to forfeit your basic rights as a citizen. The second exception is the implied contract. This one is tricky, and it gets right back to that employee handbook we talked about. An implied contract is a non-written agreement that is created through the actions, statements, or documents of the employer. Let's say your employee handbook outlines a very specific disciplinary procedure. First a verbal warning, then a written warning, then a final warning, and only then termination. Or maybe it contains language stating that employees will only be terminated for just cause or good cause. By putting those policies in writing and distributing them to you, the company may have accidentally created an implied contract. They have set an expectation, a promise that they will follow those steps. If they then fire you on the spot for a minor infraction, skipping their own stated procedure, you could argue they violated this implied contract, and your termination was wrongful. This is precisely why most modern employee handbooks are loaded with legal disclaimers. You'll see big, bold text right at the beginning that says something like, "This handbook is not a contract of employment. The policies within are guidelines only and can be changed at any time. All employees are employed on an at-will basis." That single paragraph is a powerful legal tool for the company to destroy the argument that an implied contract ever existed. The third and narrowest exception is the covenant of good faith and fair dealing. This is only recognized by a handful of states, but the idea is powerful. It suggests that even in an at-will relationship, the employer and employee have a duty to treat each other fairly and in good faith. An employer can't fire an employee to cheat them out of compensation they have already earned. The classic example is the salesperson. Let's call him Frank. Frank has been working for months to land a massive company-changing client. If he closes the deal, he's due a $100,000 commission. On a Friday, he gets the client to sign the papers. The deal is done. His commission is scheduled to be paid out the following week. On Monday morning, Frank's boss calls him in and fires him, claiming corporate restructuring. The company keeps the new client, saves itself $100,000, and Frank is left with nothing. This is a textbook example of a bad faith termination. Firing Frank for the sole purpose of avoiding a payment he had already earned violates this covenant of good faith. It's an act of malicious dealing, and in states that recognize this exception, Frank would have a strong case for wrongful termination. So, at-will is the rule, but it has limits. The problem is, these limits vary wildly from state to state. Almost all states recognize the public policy exception. A majority recognize the implied contract exception, but very few recognize the covenant of good faith and fair dealing. It creates a confusing patchwork of laws where your rights as an employee can change dramatically just by crossing a state line. Now let's bring it back to that core question from the beginning. Can your employer use the at-will doctrine to change the terms of your job whenever they want? Can they cut your pay, change your job title, or remove your best projects? The uncomfortable and often shocking answer for most American workers is yes. Because the power to terminate you for no reason at all includes the lesser power to change the conditions of your employment going forward. They can't retroactively cut your pay for work you've already done, but they can come to you and say, starting Monday, your salary will be 10% lower. Your new job title is junior associate, and you'll now be in charge of filing. You can either accept these new terms, or you can leave. It's a take it or leave it proposition, underpinned by the threat of at-will termination. This is where the true power imbalance of the at-will doctrine becomes crystal clear. It's not just about being fired. It's about the constant looming threat of it, which can force you to accept changes you would never agree to otherwise. So if at-will is the default, how do you escape it? How do you secure promises and lock-in terms so your employer can't do this? You do it with the one thing that overrides the at-will doctrine entirely: a real bona fide employment contract. And the most critical, most negotiated, and most dangerous clause in that entire contract is the one that defines how and why it can all come to an end. This is the termination clause. And it is, without a doubt, the most important battlefield in your entire employment contract. Get this right and you have security. You have leverage. You have a safety net. Get this wrong and your multi-year contract might as well be written on toilet paper. Because this clause answers the fundamental question: what happens when things go south? Let's be clear. Your employer wants maximum flexibility. They want the power to get rid of you for any reason at any time, while paying you as little as possible. You, on the other hand, want security. You want to know that if they decide to let you go for reasons outside of your control, like a bad quarter, or a new CEO who wants to bring in their own team, you will be taken care of. This entire power struggle is fought across two deceptively simple phrases: termination for cause and termination without cause. Let's start with for cause. This is the company's eject button. It means you did something wrong. So wrong, in fact, that the company has the right to terminate your contract immediately and, crucially, owes you nothing more than your final paycheck. No severance, no bonus, no parachute, just a cardboard box for your desk plant. You might think, that's fair. If I steal from the company or punch my boss, I deserve to be fired. And you're right. But that's not what we're talking about. The real danger isn't in the obvious, fireable offenses. The danger is in the definition of cause. Your potential employer's first draft of this clause will be a masterpiece of vague, subjective language. It will be a minefield designed to give them an out for almost anything. You will see phrases like failure to perform duties to the satisfaction of the board, or conduct which brings the company into disrepute, or the all-time classic, insubordination. Let's break down why these are so terrifying. Failure to perform duties to the satisfaction of the board. Whose satisfaction? It's completely subjective. Maybe you have a new manager who just doesn't like you. They can claim they aren't satisfied with your performance, even if you're hitting all your objective targets. Boom. Fired for cause. No severance. How about conduct which brings the company into disrepute? What does that even mean? You have a heated political argument on your personal Facebook page. A competitor finds it and sends it to a reporter. Does that bring the company into disrepute? Maybe. It's vague enough that they can argue it does. Boom. Fired for cause. No severance. And insubordination. This is the most abused term in the corporate world. It can mean anything from refusing a direct, unethical order to simply disagreeing with your boss too strongly in a meeting. It's a weapon. So what do? You fight back. You negotiate. You turn their vague, subjective definitions into clear, objective, and curable standards. This is non-negotiable. You must insist on a definition of cause that is narrow and specific. Here's what a good for cause definition looks like. It will typically list very specific actions: a conviction for a felony, fraud or embezzlement, a willful and continued refusal to perform your duties after receiving a written warning. Do you see the key words there? Conviction, not just accusation. Willful, meaning you did it on purpose, not just made an honest mistake. And the most important part, after receiving a written warning. This is called a cure period. A cure period is your best friend. It means the company can't just fire you on the spot for a mistake. They have to give you formal written notice that you're doing something wrong, and then they have to give you a reasonable amount of time, say 15 or 30 days, to fix the problem, to cure the breach. If you fix it, you can't be fired for cause for that issue. This simple provision eliminates their ability to use minor slip-ups as a pretext to fire you and avoid paying severance. It forces them to be fair and give you a chance to correct course. Now let's flip the coin and talk about the other side, termination without cause. This is exactly what it sounds like. The company is letting you go, but not because you did anything wrong. Maybe they're downsizing. Maybe the economy tanked. Maybe your job was eliminated in a restructuring. They don't need a reason, and that's okay. Because if they terminate you without cause, they have to pay. This is where your severance package lives. Termination without cause is the trigger for all the good stuff you negotiated. The lump sum payment of 6 months, 12 months, or even 24 months of your salary. the continuation of your health benefits, the prorated portion of your bonus, the accelerated vesting of your stock options. All of it hinges on them firing you without a valid, contractually defined cause. And now you see how these two clauses are locked in a death grip. The company will always prefer to fire you for cause. Why? Because it's free. Firing you without cause is expensive. It could cost them hundreds of thousands or even millions of dollars. This is why that definition of cause we talked about is so critical. A weak, vague definition gives the company a massive incentive to invent a reason to fire you. They can build a flimsy case for insubordination or poor performance to avoid that huge severance payout. But a strong, narrow, objective definition of cause, one that requires a felony conviction or a willful breach that you fail to cure, makes it almost impossible for them to fire you for cause unless you do something truly egregious. It removes their wiggle room. It forces them into a choice. Either keep you employed or pay the price you agreed upon to let you go. It transforms your severance package from a hopeful wish into a contractual right. But there's a third, often overlooked, piece to this puzzle. What if the company doesn't fire you, but instead makes your life miserable so you'll quit on your own? Imagine this. They can't fire you for cause and they don't want to pay your severance to fire you without cause. So they get creative. They cut your salary by 40%. They demote you from vice president of marketing to junior brand associate. They tell you your job is now based in Omaha, Nebraska, and you have to move your family across the country in 2 weeks. They're trying to force you to resign. And if you just quit, you get nothing. You walk away with zero. This is called constructive discharge or constructive termination. It's a backdoor way for the company to get what it wants without honoring the contract. That's why your contract needs a defensive shield. It's often called termination for good reason. Think of it as your own personal for cause clause against the company. This clause states that if the company takes certain adverse actions against you, you can resign and it will be treated as a termination without cause by the company. In other words, you get to pull the trigger on your own severance package. What qualifies as good reason? You need to define it explicitly in the contract. The most common triggers are a significant reduction in your base salary or bonus potential, a material diminution of your title, duties, or responsibilities, or a requirement that you relocate more than, say, 50 miles from your current office. With this clause in place, the company's make you miserable strategy backfires. If they cut your pay, you can say, "Thank you, you've just triggered my good reason clause. I'll be resigning in 30 days, and I'll expect my full severance package as outlined in the agreement." It completely closes the loophole. So when you look at that termination section, don't just see one clause. See it as an interconnected three-part system. First, a narrow objective for cause definition that protects you from pretextual firings. Second, a robust severance package triggered by a without cause termination. And third, a good reason clause that allows you to claim that severance if the company tries to force you out. Getting these three elements right is the core of a protective employment contract. It creates a fortress around your financial security. But even with this fortress built, a single sentence hidden elsewhere in the contract can act as a Trojan horse. It's a clause that can control your career long after you've left the building, dictating where you can work, who you can hire, and even who you can talk to. It's a promise that can haunt you for years, and it's called a restrictive covenant. Think of restrictive covenants as a set of golden handcuffs. They look impressive, they might even come with a great salary, but they are designed to limit your freedom. They are the company's insurance policy against you becoming their next biggest competitor, or you taking their secret sauce and their all-star team down the street to the competition. And they generally come in three main flavors, each more restrictive than the last: the non-compete, the non-solicitation, and the non-disclosure agreement, or NDA. Let's break down this unholy trinity one by one. First, the big one, the one that makes headlines and has regulators up in arms: the non-compete agreement. A non-compete clause is exactly what it sounds like. It prohibits you from working for a competitor for a certain period of time after you leave your job. Imagine you're a brilliant software engineer named Jessica. You've spent 5 years at a major tech company, Innovate Corp, developing their flagship AI product. You're a star. One day, a hot new startup, Future AI, gives you an offer you can't refuse. It's a leadership role, a massive pay bump, and a chance to build something from the ground up. You're ready to sign. But then you remember the employment contract you signed with Innovate Corp on your first day. Buried in the fine print is a non-compete clause. It says you cannot work for any company involved in artificial intelligence anywhere in the United States for 2 years after leaving. Suddenly, your dream job is a legal nightmare. This is the power of a non-compete. But here's the critical detail. For a non-compete to be legally enforceable, it generally has to be reasonable. And courts typically measure reasonableness across 3 dimensions: time, geography, and scope. A 2-year ban? That might be considered reasonable for a high-level executive, but maybe not for a junior developer. A ban covering the entire United States? If Innovate Corp only operates in California, a nationwide ban is almost certainly unreasonable. The scope is also key. A clause preventing Jessica from working in artificial intelligence is incredibly broad. A more reasonable scope might be limited to the specific type of AI she was developing, like natural language processing for financial models. The legal landscape for non-competes is a battlefield, and it's changing fast. States like California, Oklahoma, and North Dakota have already made most non-competes void and unenforceable. They believe these agreements stifle innovation, suppress wages, and trap workers in their jobs. And just recently, the Federal Trade Commission, the FTC, issued a new rule aiming to ban most non-competes nationwide, calling them an unfair method of competition. While that rule is facing legal challenges, the direction of the tide is clear. The era of the overly broad, career-crushing non-compete is coming to an end. But for now, millions of Americans are still bound by them, and you absolutely need to know if you're one of them. Now, let's move on to the second, more subtle handcuff, the non-solicitation agreement. This one doesn't stop you from working for a competitor. It stops you from taking the party with you when you leave. A non-solicitation clause has 2 arms. The first prevents you from poaching your former colleagues. The second prevents you from poaching your former company's clients or customers. Let's picture David, a top sales director at a logistics company. Over a decade, he built a powerhouse team. They trust him, they follow his lead, and together, they've landed the company's biggest accounts. David decides to leave to start his own consulting firm. He knows 5 of his former team members would jump at the chance to join him. He also knows his top 3 clients love working with him personally and would likely follow him anywhere. But his employment contract contains a powerful non-solicitation clause. For 1 year after his departure, he is forbidden from directly or indirectly soliciting any employee or any customer of his former company. This is devastating. He can start his new company, he can even compete in the same market, but he has to do it alone, starting from scratch. He can't hire the A-team he spent years training. He can't even call up the clients with whom he has built personal, trusted relationships. It's like being a general who is told he can go to war, but he has to leave his entire army and all of his maps behind. And the language here is treacherous. What does solicit even mean? If David posts about his new company on LinkedIn and a former colleague sees it and applies for a job, did David solicit them? What if a former client hears through the grapevine that David left and calls him? These gray areas are where expensive legal battles are born. Companies argue that even a hello at a conference could be a form of indirect solicitation. This clause is less about preventing competition and more about protecting a company's most valuable assets: its people and its customer relationships. It's a fortress wall built around their talent and their revenue stream, and you're locked on the outside. Finally, we have the most common, and in many ways the most powerful, of all restrictive covenants, the non-disclosure agreement, or NDA. Also known as a confidentiality agreement. Unlike a non-compete that might last for a year or 2, the obligations of an NDA can last forever. This is the clause that says, what happens at this company, stays at this company. And it covers a vast universe of information. We're not just talking about the secret formula for Coca-Cola, or the blueprints for the next iPhone. We're talking about almost everything you come into contact with at work. Confidential information can include customer lists, pricing strategies, marketing plans, internal software, financial data, and even the details of internal company processes. Think about it. In almost any professional job, you are being paid to create, access, and use the company's proprietary information. The NDA is the legal mechanism that ensures you don't walk out the door with that knowledge and hand it over to someone else, or use it to build your own competing venture. Let's consider Maria, a product manager who worked on a secret project called Project Titan for a medical device company. The project was ultimately canceled. Maria leaves the company a year later. In an interview for a new job, she's asked about her experience managing complex projects. She's tempted to talk about Project Titan, It was a massive undertaking and showcases her skills perfectly, but the NDA she signed is a steel trap. It explicitly defines all information about unreleased or canceled projects as strictly confidential. If she talks, she's in breach of contract. She could be sued for damages, and her professional reputation could be shattered. So she's stuck. She can't use a huge part of her work experience to advance her career. This is the silent power of the NDA. It doesn't just protect trade secrets. It can effectively redact your own resume. It forces you to compartmentalize your own history. And while there are legal protections for whistleblowers reporting illegal activity, for the vast majority of day-to-day business information, the NDA is an ironclad vow of silence that you are legally bound to keep, potentially for the rest of your life. These three clauses, the non-compete, the non-solicitation, and the non-disclosure, form the core of how a company attempts to control your career, even after you've walked out the door. They are a calculated effort to protect the company's interests. But in doing so, they can severely limit your mobility, your network, and your ability to leverage your own hard-won experience. They are presented as standard, non-negotiable parts of a job offer. You're handed a pen and told to sign on the dotted line. But the truth is, the enforceability of these clauses varies wildly from state to state and from court to court. They are not always the unbreakable chains they appear to be. The key is understanding the difference between a reasonable request to protect a business and an unreasonable restraint on your right to make a living. And that difference is where you find your leverage, your power to negotiate, and your freedom. So let's talk about the other side of that equation. We've dissected the clauses that take things away from you, your time, your future opportunities, your intellectual property. Now, let's focus on the reason you're signing that document in the first place, what you get. And I'm not just talking about a paycheck. That's the single biggest, most costly mistake people make. They get an offer letter, their eyes scan down the page, find the number with the $ next to it, and their brain just stops. They see a salary of, say, $80,000, and they immediately start calculating their new life around that single figure. They've already spent it in their head. But focusing only on the base salary is like buying a house based on the curb appeal without ever stepping inside to check for a leaky roof or a cracked foundation. The real value, the life-changing wealth, is almost always hidden in the fine print of your compensation package. This is the part of the contract that defines your financial relationship with the company. And it's so much more than a number. It's a collection of tools, and if you don't know what each tool does, you can't build anything with them. Let's break down the anatomy of a modern compensation package, because understanding these components is the first step to radically changing your financial trajectory. First, you have the base salary. This is the bedrock. It's your predictable, reliable income. It's what you pay your rent with, what you budget around. It's important, of course, but it's also often the least flexible part of your negotiation. Companies have salary bands, internal equity policies, and budget constraints that can make it difficult to get a huge bump in this number. They might have a little wiggle room, but they often have a hard ceiling. This is where most people get stuck. They ask for $10,000 more in salary, the company says they can only do $5,000, and the negotiation ends. The savvy employee knows the base salary is just the opening bid in a much larger game. Next up, the bonus structure. This is where things get interesting, and where the language of your contract is absolutely critical. A bonus is not just a bonus. There are different kinds. You might be offered a sign-on bonus, which is a one-time cash payment to get you in the door. This is highly negotiable, especially if you're leaving a current job and walking away from an upcoming bonus there. But you have to look for the clawback clause. A clawback means if you leave the company before a certain period, usually 1 or 2 years, you have to pay that bonus back. Suddenly, that free money feels a lot more like a golden handcuff. Then there's the performance bonus. This is where the devil lives in the details. Your contract might say you are eligible for a discretionary bonus of up to 20% of your base salary. Let's break that down. The word eligible doesn't mean guaranteed. It means you have a ticket to the lottery. The phrase up to means it could be 20% or it could be 0. And the most dangerous word in that entire sentence is discretionary. Discretionary means it's completely up to the company's whim. They could have a record-breaking year, you could be the top performer on your team, and they could still decide for any reason at all not to pay it out. A well-negotiated contract changes that language. Instead of discretionary, it ties the bonus to specific, measurable metrics. You will receive a bonus of 15% of your base salary if the team achieves X revenue target, or if you successfully complete Y and Z projects by the end of the fiscal year. See the difference? One is a hope, The other is a contractual obligation. You've turned a maybe into a mathematical certainty. Now let's talk about the big one, the one that creates genuine, life-altering wealth. I'm talking about equity. For many people, especially in the tech industry or at startups, this is the most valuable part of their compensation, but it's also the most misunderstood. It's like being handed a complex financial instrument with no instruction manual. Let's demystify it. Equity generally comes in a few flavors. The most common are stock options and restricted stock units, or RSUs. Think of it this way: a stock option is like a coupon. It gives you the right to buy a certain number of company shares in the future, at a fixed price set today. This is called the strike price. The hope is that the company grows, the share price goes way up, and you can use your coupon to buy shares for, say, $1 when they're actually worth $100 on the open market. You pocket the $99 difference. That's your profit. RSUs are a bit different. They aren't a coupon to buy something. They're a promise of the actual shares themselves. The company is essentially saying, "We are granting you 1,000 shares of stock, and we will give them to you over the next 4 years. You don't have to buy them. They're just given to you as you meet certain conditions." The most important condition for both options and RSUs is the vesting schedule. This is the single most critical piece of the equity puzzle. Vesting is just a fancy word for earning. You don't get all your equity on day one. You have to earn it over time. A typical vesting schedule is 4 years with a 1-year cliff. That 1-year cliff is a trap for the unwary. It means you get absolutely nothing until you've been at the company for 1 full year. If you leave or are let go on day 364, you walk away with nothing. Poof, it's gone. After you hit that 1-year anniversary, you're over the cliff, and a chunk of your equity vests, usually 25%. Then, the remaining 75% typically vests monthly or quarterly over the next 3 years. Understanding this is your leverage. Can you negotiate for a shorter cliff, say 6 months? Can you negotiate for accelerated vesting if the company is acquired? What happens to your vested options if you leave? How long do you have to exercise them? Some companies give you 90 days. Others are extending that to years. That difference could be worth hundreds of thousands of dollars. These aren't just details. This is the architecture of your potential wealth. Finally, there are the benefits and perks. People glance over this section, but it's a goldmine. We're talking about your 401k or retirement plan. Does the company match your contributions? A company that offers a 6% match is effectively giving you a 6% raise that you can't get anywhere else. That is free money, compounding for your future. Not taking advantage of that is like setting cash on fire. What about health insurance? What are the premiums, the deductibles, the copays? A cheap plan can cost you thousands out of pocket when you actually need to use it. Paid time off or PTO? Is it a set number of days? Or is it one of those trendy, unlimited PTO policies? Be careful with unlimited. It sounds great, but studies have shown people with unlimited policies often take less vacation because of social pressure and a lack of clear entitlement. Sometimes having a defined 3 weeks in your contract is actually better. Then there are other perks: student loan repayment assistance, professional development budgets, wellness stipends, commuter benefits. Each of these has a real dollar value. So, when you get that offer, you need to stop thinking in terms of just salary. You need to think in terms of total compensation. Your job isn't to just accept their first offer. Your job is to be an architect. You look at all the pieces they've given you, the salary, the bonus, the equity, the benefits, and you see how you can rearrange them, modify them, and rebuild them into a structure that works best for your life and your goals. Maybe they can't budge on salary, but they can give you a massive sign-on bonus. Maybe the equity grant seems small, but you can negotiate for an accelerated vesting schedule that makes it far more valuable. Maybe the bonus is discretionary, but you can get them to put specific, achievable targets in writing. This is the difference between being a passive recipient of a contract and an active participant in its creation. You have to see the entire board, not just the one square in front of you. Because once you understand the true value of every single line item in that offer, you're no longer just asking for more money. You're having a strategic conversation about value, the value the company is offering you, and the value you are bringing to them. And that conversation, the one that can add tens or even hundreds of thousands of dollars to your net worth over the next few years, all starts with a single powerful question. It's a question that shifts the entire dynamic of the negotiation and puts you in the driver's seat. So what is that question? It's simple, direct, and it fundamentally changes the negotiation from a guessing game into a data-driven conversation. When they ask you, "So what are your salary expectations?" you don't give them a number. You don't give them a range. You look them in the eye with a calm and collaborative tone and you ask, "What is the approved compensation band for this role?" That's it. 9 simple words. But let's break down why this is a tactical masterstroke. First, it flips the script. The traditional dance is designed to get you to name the first number. And whoever names the first number in a negotiation often loses. If you say you're looking for $80,000, and their approved budget went up to $110,000, you just cost yourself $30,000 a year. They will not correct you. They will smile, say that's within our range. And you'll never know what you left on the table. By asking for the band, you compel them to lay their cards on the table first. You force them to anchor the negotiation, not you. Second, it shows you're a professional. You're not just picking a number out of thin air based on what you think you need or what you think they might pay. You're signaling that you understand how structured modern companies operate. They have budgets. They have salary bands for every level and role, determined by market data. You're not asking for a favor, you're asking for the data point that you, as a candidate, are entitled to in a fair negotiation. Third, it reframes the entire conversation. It's no longer about what you want. It's about what the role is worth to the company. This is a crucial psychological shift. You are now discussing the value of the position, and your subsequent job is to justify why your skills and experience place you at the very top of that value range. Let's see this in action. The old way. The recruiter asks, "What's your salary expectation?" You nervously say, based on my experience, I'm thinking somewhere around $95,000. The recruiter, who had a budget of up to $120,000, makes a note. "Okay, 95. Let me see what I can do." The negotiation is now anchored at 95, and you'll be lucky to get 100. Now the new way. "What's your salary expectation?" You reply, "I'm confident we can find a number that's fair for both of us. To help with that, could you share the approved compensation band for this role?" The recruiter, recognizing they're dealing with a savvy candidate, says, "Certainly. For this level, the band is $105,000 to $130,000. Boom. The entire game has changed. Your floor isn't some number you guessed. It's $105,000. Your new target is $130,000. Now you can respond with, "Thank you for sharing that. Based on my decade of experience leading projects exactly like the ones you've described, and my specific expertise in X, Y, and Z, I would be targeting the higher end of that range, around $128,000. You've anchored high, within their own stated limits, and provided a clear justification. You've gone from leaving money on the table to strategically capturing the maximum available value. But this question is just the key that unlocks the door. The real treasure is what lies beyond base salary, the total compensation package. And the most misunderstood, yet potentially most lucrative part of this package is equity. For many, especially in the tech industry or at startups, equity can be worth more than your salary over the long term. But it's a minefield of confusing terms. Let's demystify it. There are 2 main flavors you'll encounter: stock options and restricted stock units, or RSUs. Think of stock options as a coupon. The company gives you a coupon, the option, that allows you to buy a share of the company's stock at a fixed, low price, called the strike price or exercise price. You get to use this coupon sometime in the future. The hope is that by the time you're allowed to use your coupon, the actual market value of the stock is much, much higher than your coupon price. You buy low with your option, sell high on the market, and pocket the difference. But if the company doesn't do well and the stock price never goes above your coupon price, your options are underwater. They're worthless. It's a high-risk, high-reward bet on the future success of the company. RSUs, on the other hand, are less like a coupon and more like a locked treasure chest. The company promises you a certain number of shares. You don't have to buy them. They are granted to you. However, the chest is locked and you only get the key, meaning the shares become fully yours over a period of time. This is called vesting. As long as the company's stock is worth more than 0, your RSUs will have value when they vest. It's a lower risk and often very valuable form of compensation, typically offered by more mature, publicly traded companies. Now, when a company offers you equity, whether it's 10,000 options or 1,000 RSUs, that number is meaningless without context. It's like someone offering you 10,000 of currency. Is that 10,000 Japanese yen, which is about $65, or 10,000 British pounds, which is over $12,000? You need more information to determine the value. The first critical piece of context is the vesting schedule. The universal standard is a 4-year vest with a 1-year cliff. This means you get 0 equity until you complete 1 full year of service. This is the cliff. If you leave on day 364, you get nothing. It's a loyalty mechanism. After you hit your 1-year anniversary, you typically vest 25% of your total grant. Then the remaining 75% vests in smaller chunks every month or every quarter for the next 3 years. You have to understand this schedule. It dictates how long you need to stay to realize the full value of your grant. The second piece of information crucial for options is the strike price. This is the price you'll pay per share. This is usually set by a formal valuation of the company, called a 409A valuation, and should be low. The lower the strike price, the higher your potential profit. The third and most important piece of information is the total context of the company. You need to know the total number of shares outstanding. Being granted 10,000 options is great, but it's far more valuable in a company with 1 million total shares than in a company with 100 million total shares. You can and should ask, what percentage of the company does this grant represent? Or, based on the last round of funding, what is the implied value of this grant? A company that is cagey about this information is a red flag. Transparent companies want you to understand the value you're being offered because they want you to be motivated. And just like salary, your equity grant is negotiable. You can negotiate for more shares. You can negotiate for a shorter vesting schedule, though this is rare. But one of the most important, and often overlooked, points of negotiation is an acceleration clause. What happens if the company gets acquired a year and a half after you join? According to your standard vesting schedule, you've only vested a fraction of your equity. The rest just disappears. You miss out on the massive payday you worked so hard for. An acceleration clause protects you from this. There are 2 types. A single trigger acceleration means that in the event of an acquisition, all or some of your unvested equity vests immediately. A double trigger acceleration is more common. It requires 2 things to happen. The company is acquired, and you are terminated without cause as a result of that acquisition. This ensures that if the new owners decide to clean house, you still get the equity you were promised for helping build the company to that point. Fighting for a double trigger acceleration clause in your offer can be the difference between a life-changing windfall and walking away with next to nothing. So, you've used the magic question to get the salary band. You've pushed for the top of the range. You've clarified the equity offer, understood its real-world value, and negotiated an acceleration clause to protect your investment of time and talent. You're feeling great. You've secured a fantastic financial package. But the truth is, the negotiation has just begun. Because the most dangerous parts of an employment contract aren't about what the company gives you. They're about what they can take away. Hidden in the legal jargon are clauses that can control your future career, claim ownership of your personal projects, and even sue you for leaving. And we're going to expose them next. Let's start with the one that gets the most attention, the career killer in waiting, the non-compete agreement or NCA. On the surface, it sounds simple. You agree that for a certain period of time after leaving the company, you will not go work for a direct competitor. The logic from the company's perspective is to protect their trade secrets, their client lists, their special sauce. But in practice, it can become a pair of golden handcuffs that locks you out of your own profession. Imagine you're a talented software engineer at a mid-sized tech company in Austin, Texas. You've spent 3 years honing your skills in a very specific niche: AI-driven logistics optimization. You're a star. A bigger, more innovative company, a direct competitor, reaches out with an offer that would double your salary and put you in charge of a groundbreaking project. It's the dream job. But then you remember the employment contract you signed 3 years ago. Buried in page 7 is a non-compete clause. It says you cannot work for any company involved in logistics software within a 100-mile radius of Austin for 2 years after leaving. Your dream job is in Austin. Your family is in Austin. Your life is in Austin. Suddenly, your expertise has become your prison. You are legally barred from taking the best opportunity of your career. This isn't a rare hypothetical. It's a reality for millions. And the key legal concept that determines if you're trapped is reasonableness. Courts will typically look at 3 factors: geographic scope, time duration, and the scope of the restricted activities. A clause that says you can't work for a rival coffee shop within a 5-mile radius for 6 months? That might be considered reasonable. A clause that says a cashier at a fast food chain can't Work in any food service business in the entire state of California for 5 years? That's absurdly broad and would almost certainly be thrown out. The problem is the massive gray area in between. Companies often draft these clauses to be as broad as possible, daring you to challenge them. They know that the mere threat of a lawsuit, with its crushing legal fees, is enough to scare most former employees into compliance, even if the clause itself is unenforceable. The ground here, however, is shifting dramatically. The Federal Trade Commission has proposed a new rule that would enact a near-total ban on non-compete clauses nationwide, calling them an unfair method of competition that suppresses wages and stifles innovation. While this rule is still being finalized and faces legal challenges, it reflects a massive tide turning against these restrictive covenants. Some states are already ahead of the curve. California, North Dakota, and Oklahoma have long banned them almost entirely. Other states, like Washington and Illinois, have banned them for workers earning below a certain salary threshold. The takeaway is this: never assume a non-compete is ironclad. Its power varies wildly depending on your job, your salary, and most importantly, the state you're in. Closely related, and just as dangerous, is the non-solicitation agreement. This one comes in 2 flavors. The first is non-solicitation of customers. If you're in sales, this is critical. It means for a set period, you cannot contact your former clients to try and bring them over to your new company. You spent years building relationships, earning trust, and creating a book of business. You leave, and that clause legally severs those connections. You have to start from scratch. The second flavor is non-solicitation of employees. This prevents you from poaching your former colleagues. Let's say you're a marketing director who leaves to start your own agency. You know your former top graphic designer is brilliant, underpaid, and would be the perfect partner for your new venture. But the non-solicitation clause you signed forbids you from even offering her the job. The company's argument is that they invested in training that team, and you can't be allowed to just dismantle it for your own benefit. From your perspective, it feels like you're being punished for building a strong, loyal team. It's another way a contract can reach beyond your own employment and dictate your future business relationships. Now, let's move from who you can work with to what you can create. This brings us to the most misunderstood and potentially devastating clause of all: the invention assignment or intellectual property clause. Most people assume this only applies to things you create at work on a work computer for a work project. That is a dangerously naive assumption. Many of these clauses are written so broadly that they can lay claim to inventions and creations you develop in your own time, on your own equipment, in your own home. Think about the classic Silicon Valley trope. A programmer at a big tech firm spends her nights and weekends in her garage, fueled by pizza and passion, building a revolutionary new mobile app. The app has nothing to do with her day job, but it could be argued it's related to the company's business, a common phrase in these agreements. If her app takes off and becomes a billion-dollar success, that little clause she signed on her first day could give her employer a legal basis to claim they own her entire creation. They could argue that the skills she used, the background knowledge she possessed, were all developed while in their employ, and therefore, the fruits of those skills belong to them. The language to watch for is terrifyingly vague. All inventions, conceived or developed, during the period of employment. Some will add modifiers like related to the company's actual or demonstrably anticipated business, or that result from any work performed by the employee for the company. But how do you define related to? If you work for a social media company and you create a new photo editing app on the side, is that related? A lawyer could certainly argue it is. This is why some states, again like California, have laws, often called invention assignment statutes, that specifically protect an employee's ownership of an invention if it was developed entirely on their own time, without using any company equipment, supplies, or trade secrets. But if you're not in one of those states, you need to read this clause with extreme prejudice. It could be aiming to own not just your 9 to 5 but your 5 to 9 as well. Finally, there's the clause that tries to control your voice, the non-disparagement clause. This goes beyond protecting confidential information. It's an agreement that you will not say, write, or otherwise communicate anything negative about the company, its products, or its management, often forever. In the age of social media, this is a muzzle. It means no honest Glassdoor review about a toxic work environment, no LinkedIn post detailing why you left, no tweet criticizing a company policy. You might think, I'm a professional, I wouldn't do that anyway. But what if you witness illegal or unethical behavior? What if you're a victim of discrimination? A broad non-disparagement clause can create a chilling effect, making you feel legally prohibited from speaking the truth about your experience. And here's the kicker. Many of these clauses, when written too broadly, are actually illegal. The National Labor Relations Act gives most private sector employees the right to engage in concerted activities for the purpose of mutual aid or protection. This includes the right to discuss wages and working conditions with colleagues. A non-disparagement clause that could be interpreted by an employee to forbid them from, say, complaining to a coworker about their low pay could be deemed an unlawful violation of their rights. But just like with non-competes, companies put them in anyway, counting on the fact that you don't know your rights and that the threat of a lawsuit is enough to ensure your silence. So you're staring at a contract filled with these landmines. A non-compete that locks you out of your industry, an IP clause that wants to own your dreams, a non-disparagement clause that wants to take your voice. You feel trapped. Do you just sign it? Do you walk away from the job? The answer is neither. The power you have in that moment is bigger than you think. And in our final part, we're going to show you exactly how to use it, how to push back, and how to turn a contract of control into a contract of opportunity. So let's talk about that power. The moment that contract hits your inbox, the entire dynamic of the hiring process flips on its head. For weeks, maybe months, you've been the one trying to prove yourself. You've been the one answering the questions, doing the song and dance, hoping they pick you. But now, they've picked you. They have stopped looking at other candidates. They've had internal meetings, they've gotten approvals, they've invested dozens, maybe hundreds of man-hours into selecting you. They want to close the deal. They are emotionally and financially invested in you saying yes. This is your moment of maximum leverage. The fear you feel is a ghost. It's the leftover anxiety from the interview process. The reality is you are now in the driver's seat. Your first step is not to immediately sign, nor is it to immediately fire back a list of demands. Your first step is to breathe. And then you send a simple professional email. Something like this. Thank you so much for the offer and for sending over the employment agreement. I'm very excited about the opportunity to join the team. I'm going to take a day or two to review this thoroughly, and we'll get back to you with any questions. That's it. You've just done 3 critical things. You've expressed gratitude and enthusiasm, which keeps the relationship positive. You've set the expectation that you are a professional who carefully reviews legal documents, not someone who just blindly signs things. And most importantly, you've bought yourself time. Time to think, time to plan, and time to arm yourself. Now, you open that document and you don't see it as a set of rules. You see it as a proposal, a starting point for a conversation. You are about to become a collaborator in drafting your own career. The most effective way to do this isn't with aggression, but with precision and professionalism. We're not crossing things out in a fit of rage. We're making suggestions for clarity and mutual benefit. Every change you propose should be framed not as a demand, but as a way to create a better, clearer, more successful partnership. Let's start with the big one, compensation. The number they offered is almost never their final number. But saying I want more money is the amateur move. The professional move is to anchor your request in data and value. You say, I've done some additional research on the market rate for a role with these specific responsibilities in our geographic area, and roles of this seniority are typically compensating in the range of X to Y. Given my experience and mention a key skill, and the results I achieved at previous company, I'm confident I can deliver significant value from day one. Would it be possible to adjust the base salary to Z to be more in line with the market and the value I plan to bring? See the difference? You're not just asking. You're building a business case for your own salary. It's collaborative, it's data-driven, and it's incredibly difficult for them to argue with. And don't forget the other levers. Is there a bonus? Is it guaranteed or discretionary? Can the performance metrics for that bonus be more clearly defined in the contract so there's no ambiguity later? If there's equity, when does it vest? A 4-year vesting schedule with a 1-year cliff is standard. But can you ask for accelerated vesting if the company is acquired? These aren't greedy questions. They are smart questions that align your financial success with the company's success. Next, we move to the section that everyone skips but is arguably the most important for your long-term security: termination and severance. This is your exit ramp. Right now, everyone is happy and excited, but business is business. Things change. You need to plan your parachute while you're still on the ground. If the contract says they can terminate you for cause, that term needs to be defined and defined narrowly. Cause shouldn't be a vague failure to perform duties to the company's satisfaction. It should be specific, objective things like conviction of a felony, gross negligence, or material breach of the agreement. Why? Because if they can fire you for a vague, subjective reason, they can avoid paying you what you're owed. And that brings us to severance. Many initial contracts will offer zero severance. This is a negotiating point. Your position should be, in the event of a termination without cause, I'd like to build in a safety net to ensure a smooth transition. A reasonable ask is 1 month of severance for every year of service, with a minimum floor. Maybe that's 3 months. This isn't about planning to fail. It's about mitigating risk. You are giving up a secure job to join them. You are taking a risk on them. It's perfectly reasonable to ask them to share a tiny portion of that risk by guaranteeing you a soft landing if things don't work out for reasons outside of your control, like a layoff or a change in strategy. Frame it that way. To provide a bit of security for my family as I make this significant career transition, could we include a severance provision for termination without cause? It's human, it's reasonable, and it shows you think ahead. Finally, let's defuse those landmines we talked about, the non-compete and the intellectual property clauses. These are often written so broadly they are essentially unenforceable, but a company can still use them to scare you into submission. Your job is to make them reasonable. If the non-compete says you can't work for a competitor anywhere in the world for 2 years, that's absurd. You push back. I understand the company's need to protect its interests, but this clause as written would effectively prevent me from earning a living in my chosen field. Could we narrow the scope to a specific list of direct competitors, limit the geographic area to states where the company actually operates, and reduce the duration to a more standard 6 or 12 months? This isn't a rejection, it's a reasonable edit. You're showing you respect their goal, but you also respect your own career. For the intellectual property clause, the danger is that it claims ownership of anything you create, even on your own time using your own equipment. This is especially dangerous for developers, writers, or any creative professional with side projects. The fix is called a carve-out. You propose adding a sentence like, "This agreement does not apply to inventions or creations developed entirely on my own time without the use of company equipment, supplies, facilities, or trade secret information." You can even attach an addendum listing the personal projects you're already working on, just to make it crystal clear that they belong to you. Once you have your handful of proposed changes, and you should pick your battles focusing on the 3 or 4 most important points, you compile them in a polite, organized email. List your points clearly, explain your reasoning for each one using the collaborative language we've discussed, and reiterate your excitement for the role. Then you get on the phone to talk it through. Be calm, be friendly, be firm. And what if they say no? What if they say, "This is our standard contract, we don't make changes"? First, understand that this is often just a starting negotiating tactic. You can respond with, "I understand the desire for a standard agreement, but I'm hoping we can make a few small adjustments to make this a perfect fit. The severance provision, for example, is a key point for me in making this transition." You hold your ground politely, but if they truly refuse to budge on any reasonable request, if they rescind the offer because you had the audacity to negotiate professionally, then you haven't lost a job. You have dodged a bullet. A company that rigid, that unwilling to have a reasonable conversation, has just told you everything you need to know about their culture. They have shown you that they don't view their employees as partners, but as cogs in a machine. This entire process, from the moment you receive that offer to the moment you sign a revised, improved contract, is the first and most important project you will do for your new employer. It demonstrates your communication skills, your attention to detail, your business acumen, and your ability to advocate for a positive outcome. You are not just negotiating your salary. You are negotiating the terms of your relationship. You are setting a precedent that you are a valuable partner, a strategic thinker, and someone who understands their own worth. An employment contract is not a set of commandments carved in stone. It is the beginning of a story, the story of your career, your growth, and your success. By learning to read it, to understand it, and to shape it, you are seizing the pen and becoming the author of that story. Don't ever let anyone else hold it for you.